Did you ever hear me explain about my mom? That my mom was an IRS tax. Okay, so like I said to you guys, you guys know that all you have to do is ask the person who's assessing you, who's sitting across the table from you, is to sign that piece of paper and say, I owe it, and I'll be more than glad to pay it. But all I needed to do is have you sign it, so that way if you're wrong, I could hold you liable.
In my thing, they've never come face-to-face with me, and they switch people all the time. They never put anybody with their signature on the line. I guess I could, the only thing I could do is...
Of course you could demand it. Of course you could say if somebody's making a claim against your property, if somebody's demanding that you relinquish something, somebody has to have the right to do that. Nobody could do it unless they have the right to do it.
Right.
You see what I'm saying? And they could provide some statutory code and stuff to say, okay, that's fine, that's special. Now I'm going to hold somebody personally liable if they do it in error, and it causes me harm. I'm going to need some man or woman to put their John Hancock on that document. And I'll be more than glad to pay the assessment.
Mm-hmm.
Or if I believe the assessment's in error, I'll be more than glad to take that man or woman into a common law court of record, and I will dispute the claim in front of a jury. And they'll be popping out pickles.
Yep. I guess I got to flush them out.
There you go. That's the whole thing, man. You gotta talk extremely nice and extremely simple. And like I said, I know the Dean style, and my style is just sweeter than pie. You just go in there and just this. I'd be more than glad to do it. That'd be a lovely thing to do. Just show me, can I please have somebody's autograph on here? Can somebody please sign this and claim that I'm liable? Somebody please make a claim. I love settling claims. I will not argue with the fact. I will not make complaints. I'm not going to argue, stand here and listen to complaints. I will answer all claims tended to my person. You say nonsense like that, and the attorney will curl his toes. So just download this recording. I'm going to save it for you folks. So that way I don't have to repeat it again, because, boy, that was sweet.
That's good.
Like I said, it'll curl his toes. So thank God I figured out how to do this talk show thing, and you guys who just listened to the past episodes. I already did an episode to try it out earlier.
I'm glad you did it, because that Charles guy, what an obnoxious, and then he brought Colin on. Boy, I wanted to hang them both, strangle them.
Well, what it was is I wanted him to be the host. I wanted to just be a guest. And I just wanted to go around and ask people like Dean, hey, I got a show called The Uncommon Law. I said, now, I'm going to try to get a host like a Charles or somebody to be the host, because I really don't want to be a host. I'd like to take a time out from talking so damn much, and I'd like to be the guest. We'll have 2 or 3 guests on. That'd be great. Like I said, somebody called me up the other day from Oregon or Washington State. I hope he listens to this call. And he was talking to me about the Lieber Code. And he's like, wow, you really like the Lieber Code, and you told me, I said, of course, it's wonderful. The Lieber Code's a wonderful process in military law. I said, I love it. He said, but I thought you were all common law. I said, sir, look, all types of different jurisdictions you're going to run into. I said, when I try to use international, like maritime law, if I'm dealing with citizens of France, my common law bullshit goes out the window. I'm going to have to adjust my claim, depending on the jurisdiction, the property. So believe me, I'm not one of these knuckleheads who just say common law is the only thing, everything, and nothing else. Oh, I'm going to maybe have to move in different jurisdictions and deal with people, maybe who want to move their claim into their jurisdiction. And I'm going to have to adapt to it. So I said, he's like, wow, well, you really know the Lieber Code, and I'm really surprised you didn't jump on me and make fun of me. I said, no. I said, it's a wonderful thing. I said, and anytime you want to come on, I'll start a show, and we'll just go around and around about the Lieber Code, why it's good or why we could use it and how we could use it, where we could use it, and where we shouldn't use it. You don't want to start going gold fringe on the people and start going too much Lieber Code on these guys.
Mm-hmm.
But sometimes, throw it in there. It might actually come in handy. It's nice to know it. So it's just nice to know. It's just nice to have, and especially if you hear them coming at you with something silly like that, you're like, oh, I see where this is going. He's going to leave a code on me. Aha. You know what? I'm going to drag this around. We're going back common law. But that was cute. I liked how you tried to jump jurisdiction on me. Because like I said, when I got around and around with the governor's attorney, I said to him, you notice the order that the magistrate passed in the federal court under my case? He was like, yeah, did you notice in the first paragraph, how many jurisdictions did he basically state? He said 4. I said, yeah, you noticed that too. He was bouncing me from like maritime, admiralty, common law. He was bouncing me all over the place. And he even threw his own personal jurisdiction in there. He believed that this was his case and he was going to move it. I said, did you notice that? That was pretty sharp how the guy did it. I said, I really enjoyed it. He's like, yeah, I was trying to figure out, the man's name was Franklin Johnson. He was the governor's attorney. He was like, yeah, I kind of trying to figure out where he was going with that too. I was like, maybe he didn't think I realized that he was trying to move it out of the common law side of the court and try one of these other 3 options. I'm not going to let him do that. I'm dragging him right back to my side of the court. But I guess he's going to think I'm going to not notice that he just whipped out 3 entirely different jurisdictions in one paragraph, and I'm just going to let him get away with it. So once you realize the different jurisdictions that these courts are ordering you to abide by or move under, you say, no. No California Code 1234. No ordinance this. No rule of civil procedure this. No. We're moving it back over here. But they're going to try. And like I said, when attorneys talk in court and judges talk in court to each other, they will move the jurisdiction so fast it'll be like lightning. You say, excuse me, guys, I object. He's like, what? Get it back to this side of the court. None of that nonsense. You can't bring none of that nonsense. That's not the law before this court. What's the law before this court? The common law. This is the law that I've moved because this is my claim. Don't try to drag it under some other jurisdiction. That's why I tell people, your claim has got to be 1 sentence long because that's common law. If you do not say it exactly the same way all the time, like I say, you uttered a forged instrument in which had interfered with my right to property. There you go. And that's all I keep saying. It's like, well, what are you here about? Oh, I'm here because utterance of a forged instrument has interfered with my rights to property. And the judge will say, well, is there anything more to your claim? No, it's just they uttered a forged instrument which interfered with the rights of my property. And the judge will say, oh, okay. And I'm done. And then the other side will go. The other side will say, well, we don't believe we uttered a forged instrument to interfere with my rights to property. They say, okay, well, would you like me to expand on it? Would you like me to present the evidence to the court now? Is this court ready to see my exhibits and take my testimony and have the witnesses appear before it? And the judge will say, well, okay, well, sure, let's see it. But you state your claim. If you make your claim in the very beginning anything other than your simple sentence, you just lost common law jurisdiction.
Sure.
You start bringing in all kinds of different examples. You say, well, they uttered a forged instrument and interfered with my rights to property. And under California Code 1234, that's illegal. It's like, well, okay, which code? Where are you moving this call? Is this common law call? Or are you moving under California Code of 1950? Which one are you doing, call? And if the other side doesn't object, then the other side will start whipping out all kinds of nonsense on their side, too. And it'll be a free-for-all. There could be 4, 5, 6 different jurisdictions going on, different codes going on. So you got to stop everybody and say, whoa, get rid of that. No. This is my claim. This is my law before the court. The court's to determine whether my law is good law, not his law. He can't bring that law into this court. He can't bring that code nonsense. I don't know where she got that code from. I didn't like that code. That's not what's before this court at this time. The interpretation of my law is before this court at this time. Not his interpretation, my interpretation of the law. This is what I say the law says, and this is how he interfered with my right under this law. And they have to drag him back. It's like, well, answer the man's law. Did you or did you not interfere with his rights according to his law that he brought into the court? The right to be left alone, or the right not to be trespassed. But everything's basically a trespass. So did you trespass upon this man? Yes or no? Which means the right to be let alone, or tons of rights. Almost every single thing that they possibly do to you is a trespass. So that's why I always make my claims in common law trespass. And then under that, I'll say forgery. And that's basically what my lawsuit said. It said on the front cover, it said trespass and forgery. That's all. What type of trespass? Forgery. What is forgery? You create a false document in which led to somebody's home. Somebody believed in it, and they found out later on it wasn't true. That's all. And that's what I say to folks. You got to get in and out of court so fast, it's scary.
I notice when you do your notices or your documents here, you're signing at the bottom, but I don't see any kind of a jurat or if you're going to verify, you say you like to verify what you do.
That's all I say.
You put some kind of wording?
Yeah. Well, you say I verify. Well, I say it at the very beginning. At the very beginning of the document, I say I verify it be true. And at the bottom, you can say at the very top where you do the caption, you could state it as well. You could say verified claim or verifiable claim at the very top, like where you do trespass, and then you do the colon, and then you write forgery, and then you make another space, and you can say verified claim. And there you go. If you want to do it at the very bottom, don't ever do that nonsense the lawyers do. If you see something that comes back saying, I certified, blah, 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 that's a lawyer.
Under penalty of perjury and all that?
That's a lawyer. A certification means zero. There is no way you could be held for perjury or for crime or for false or lying or for anything just because you say you're certified. Verified is where you get them. You say to them, when you answer my claim, I will only accept verifiable answers. I will not accept certified answers. I will only accept verifiable answers because you're just wasting my time if no man's going to appear. Anybody can certify anything. I mean, like a notary, she could certify anything. She doesn't know what's on that paper. You go to the bank lady, she's making, $5 an hour, $10 an hour. You say, hey, who does a notary here in this bank? Oh, she does. You say, okay, can I see your driver's license? Yeah, okay. Okay, that looks like you. Okay, boom, boom, she stamps and hands it back. And now, can she go to open court under oath of affirmation and verify anything in that document is true?
Nope.
No, she doesn't know what the hell you wrote. You could have basically handed her a blank piece of paper. You could have put a big X on it, and she would have signed a stamp and said, well, that's kind of weird. Okay, but you pay me $5, I'll do it for you, or your bank customer, I'll do it for you. Okay. Kind of seems goofy, but okay. I'll say that this piece of paper was before me on this date, March 28, 2013. Okay. And that's it. That doesn't mean anything on that is true. So when an attorney says, well, this is certified and notified and notarized, I don't give a damn. Notarized and certified, big deal. So that piece of paper existed in front of somebody other than you. Wow, whoopee-doo. Is somebody going to verify any of this nonsense on this paper? That's all I want to know. Is somebody going to come to court and answer any of this crap verbally, open their mouth, in viva voce, and swear under oath of affirmation that all in there be true? No, well, then you're wasting my time. Because this is going to be over in 2 minutes. If nobody's going to come to court and verify any of this nonsense, I win. I'll verify it in court, yeah. The other side will say, are you going to verify any of this stuff? Oh, hell no. Attorney will say, oh, hell no. He's going to say, I know what the word verified means. I ain't going to open my mouth and say shit. And that's whenever we say to people, look at that Richard Cornsworth's video about Trinity versus Pagliaro. That's where I learned it from. And no attorney can motion a court or order a court to make summary judgment because it did not come through oath of affirmation with any first-hand knowledge from any competent witness. Competent, because the attorney can't testify in a common law court. He's not competent. So it's kind of funny hearing that an attorney's not competent. Is that attorney competent? No. So they say, well, look, we're just Joe Sixpack, Joe Normals. We're not competent. Bingo. We're not. And be happy you're not competent. Because you're not competent to stand in the statutory court. That's right. That's why they provide you with a decipher code reader for you, an attorney. They'll decipher the code for you. I don't want one. I want to take it to a common law court where I don't need no stupid code enforcement officer to decipher my stuff. Plus, I get to block every attorney. Was an attorney, you a competent witness here? No, you're incompetent to testify, right? Yeah, I'm incompetent to testify. What, so should I demand the court take him to a psychological evaluation until they rule him competent? That's ridiculous. Could be pretty funny. Say the judge, well, I move this court to hold him for an incompetency hearing until he can prove to the court that he's competent to answer in this court. Yeah, take him away until he can prove he's a normal six-pack man and he stops talking this legalese gibberish. Yeah, then let him come back and stand and testify. That's all they're doing when they're saying it's a competency thing, and which is even sillier because the people they send you to for competency, they're psychologists. They didn't go to law school. They didn't pass the bar.
Right.
Now, what kind of questions are they going to ask you? They're going to ask you, well, what was the ruling in Hale versus Hinkle? Or what was the impact of Fuller versus Johnson, 1947? They're not going to answer you that stuff. So what do they mean by competent? You have to know what they mean by competent. Do you understand the nonsense, this code that this man's saying? No. Is there any law that requires me to know? No. It's just that simple. I'm glad I'm incompetent because I don't have to stand here and speak to any of you.
Right.
And you can't.
What does it take to rescind this or revoke this contract? The short little statement you made in there that I got, and then to finish it, you just would sign it yourself, or would you have to get it?
I'd say to people, be incredibly polite. Say, oh, if I was sorry for any inconvenience, but I was incompetent. I'm incompetent to stand on, incompetent to engage in any intercourse and commerce with you folks. Just be really sweet about it, and just say, I'm not competent to enter into such a foreign agreement. That way you have no standing because you have no status, because you have absolutely no idea, because you're not the person who wrote the code, you're not the person who wrote the contract up, you have no capacity to understand any of this nonsense because you don't know who even created this damn thing. You just say, it's not my wish, to be engaged in this, in this endeavor. You could say it as nicely as you want to. Say, I did not create this. I have no idea who this person who's trying to contract with me is. I'm not competent in this code. There's nothing in law that requires me to be competent. And I just can't accept this wonderful benefit of this gift at this time because I perceive that it was going to cause me harm. That's what I try to say to people. Just because you get a presentment or a gift doesn't or benefit, they might think it's a benefit, but you don't have you have to accept it, but then you could send it back and say, you know what, I thought it was a great gift at that time. I thought I could really handle it, but you know what? It's overwhelming. It's actually causing me great harm and stress, and it's actually causing a lot of, and I just can't do it. And I know you, good, kindly person on the other end of this letter, certainly doesn't want to cause harm to man because your agency or your government was created by man, and it's not to be the source of harm to man. It's supposed to be a source of benefit to man. So, however you want to spice it up to try to make it sound, palatable.
It's like you explained earlier, where an administrative agency, it's the rule of law is on their side, 51%.
Yeah. Oh, yeah. When you're standing in their jurisdiction,
right,
before an administrating hearing officer, because if it's not a trial, it's a hearing, and he's just a hearing officer, and he's not bound by no constitution. He's not bound by any set of rules other than the law that administrative agency is running under. He's bound by their rules. And like I said, rules are the most ridiculous. On a pyramid, the rules are at the bottom. The laws customs are at the top, and then laws under customs, if you're looking at a pyramid. Rules are at the bottom. Because like I said, my sister was his school teacher, and one day she said to the kids, we're bored with playing kickball. Let's run third base, second base, first base. Let's break the rules, because rules are made to be broken, to just spice it up and just, jazz it up a little bit. But the customs are the customs. The law is a little bit, can be modified or interpreted, but the customs of the people, that's what always prevails. In this nation, customs are at the top, and then laws underneath.
So that being true, that means that's how they get you, because you say, I don't consent. Well, you don't get the right not to consent, because it's 51% on their side that they believe you consented.
You say, like I said to Dean, this is very simple. I require leave of court so I could properly answer the claim before this court. And I know there is a proper claim been submitted to this court. Is that not true, Judge? And he knows it's not true. There is no claim. It's a complaint. He knows the difference between a claim and a complaint. Only a man can make a claim. So he'll be like, see, that's what Dean's keeps jumping up and down, because I said that to Dean back in November. I said that to him. I said, Dean, I watched your videos. You're a nice man, but, I think you're going to get it, but you're a little angry. I said, what you really need to do is stop using their acts, stop using the Canadian Constitution, stop using the Canadian law, stop using their precedents. He's like, well, I said, Dean, first of all, that's intellectual property theft. You can't do it. And two, you automatically lose your common law jurisdiction by citing their code. You're dragging your claim into their code world. So they have the right to answer in a code. Like I say to people, it's like, oh, you want to write pro se on your paperwork? You want to write in Latin? You know what I'm saying? You've seen people write proper pro se, right? Right?
Right.
So now, do you think that's a legitimate thing to do, like write proper persona or something?
Hell no.
Why not?
Well, because that's something they dream up, the attorneys.
Well, no. That's it's Latin. It's Latin. It's
you did explain that is the, I don't remember what you said about it, but you did explain it.
It's Latin. It's Latin. It's a proper language. But say I write proper persona on there. And say then somewhere else I'm going to use this big YouTube video PhD degree I got from watching YouTube videos, and I'm going to throw another Latin word in there somewhere. And then somewhere along the line I'm going to say not pro tunc, and I'm going to throw a couple more Latin words in there, right?
Hmm?
Because I got this PhD from watching YouTube videos, right?
Right.
How would you like it if their answer was 100% in Latin? Because you spoke Latin.
Right.
Who's to limit them from making the whole entire complete answer in Latin?
Right.
If that's what you wish to speak in Latin, you wish to speak in Latin. That's why I tell people, stop your big 3-syllable words, $2 words, stop being a Philadelphia lawyer. Speak in 1-syllable, syllables, 2-syllable, plain language, English, simple, common law, nation, the words that we use. It was like I just went around with some guy on the phone. I said to him, stop writing a writ of habeas corpus. He said, just order for the property to be returned to the proper jurisdiction. And he said, well, writ of habeas corpus. I said, that's a legalese term of art. Let me put it this way. I said, you walk into McDonald's, you say to anybody behind the counter, oh, I'd like to place a writ with you right now. And they'd be like, you'd like to do what? Oh, I'd like to place my writ now. And the lady in the window would be like, what the hell you'd want? We don't serve writs. Yes, you do, ma'am. You take writs all the time. That's all you do all day. If you don't take writs, you don't make money. And they'd say, sir, can you just please drive through and come to the window? Because I don't understand what the fuck you're saying. I said, or you can say to the man in McDonald's or the woman in McDonald's, I'd like to place my order now. They say, oh, bingo. I know what you want. You want to place an order. So maybe the manager will walk out of the back and say, what does he want? He wants to place a writ. He wants to place an order with you. Just take his freaking order. It's like, buddy, why you got to talk all silly shit like that? You know she's just a common lady. Just say, I want to place an order. I said, that's how you make your writing before the courts. You just make it in simple, plain language. None of these big words, because if you want to go big words, they're going to go big words. If you want to rely upon Hale versus Hinkle, they're going to use the Feldman-Roca doctrine on you. And then that's it only takes like 6 semesters for a typical law student to understand the Feldman doctrine. But if you want to say, well, I'm going to rely upon the Erie doctrine or Hale versus Hinkle, well, they'll throw the old Feldman doctrine on you as an answer. Now go ahead and decipher that nonsense. So you see what I'm saying about keep it simple?
Sure. Yeah.
It's like magic. Stop using YouTube PhDs that everybody's getting online and keep it simple. And we can move through these courses like lightning. 1 sentence, done. Does anybody got a claim? No, I'm done. I require leave of court. Is there a proper claim before this court so I can properly answer it? Yes or no? Look over to the other side. You got a proper claim so I can answer it? No? Huh. Judge, what are we doing here? Is he making a false claim before this court? What's he doing? You know what? Now I'm going to need to leave a court to make a claim against his false claim. I'll be right back. Give me about 20 minutes. I'll have a claim written for you. It'll take me 1 sentence. I'll be done. Well, no, that won't be necessary, Mr. Lentz. That's all you intend to do in court. Not jump up and down and get mad and angry. I know my rights, and you are a free man, and you spell my name in all uppercase. And I don't give a rat's behind if a chicken tap dance is on my paperwork. I say, that's my name. What? That's my name. But it looks like a symbol from the artist known lately as Prince. Yeah, it kind of looks like his nonsense. All our letters are just a form of hieroglyphics. All our letters is just a form of a symbol in which we interpret to mean a certain thing. So space aliens are going to come down and read us gibberish and go, oh boy, that's English hieroglyphics from the 19th century. And they're going to try to decipher our nonsense. It's just symbols. That's all it is. See, this name nonsense, that's what I tell people. I said, boy, man, I wish I really was on this name kick, because I could really waste everybody's time for 2-3 hours on all this bullshit I've learned over the years of what the name means this, and uppercase, boy, I should sure waste your time on stuff that has absolutely nothing to do in this nation. In this nation, it doesn't matter. Like I said, any simple person could go before a court and point their finger and said, that man owes me $50 and he won't pay me back. That's a claim. There's the injury, there's the wrong, there's the harm, there's the loss, there's the breach of contract. Hey, I got it. Because the man doesn't have to know how to sign his name. The man doesn't have to write his name. This is a nice, simple country. Because everybody who moved to this country, like my dad, he couldn't read or write English. He spoke German, and he could read a little German. But he certainly couldn't read or write English. But you better believe if he had to go to court, he could hold his own. That's how this country was made, because people from all over the world were coming here. And they just said, okay, you know what? What's the custom of the people? How do you Italians do it? This Italian did this. I have no idea what you guys are doing. Eskimo did this to another Eskimo. Is that a proper thing to do to another Eskimo? You know, it's like, yeah, that's what we do all the time. We rub noses to each other. It's like, okay, fine, you know, that's what we do. Or this is what we do with a polar bear. Oh, I didn't know. I thought that was pretty bizarre. But no, it's a custom of other people. That's not unlawful. Okay, but, you know, you try to do that in New York City to somebody, they'll punch you in the face. You say, oh, no, we rub noses here all the time. Oh, I don't know. You rub a nose with a polar bear? Yeah, we rub a nose with a polar bear. Oh, you're pretty crazy. You rub a nose with a complete stranger? Oh, yeah, complete stranger. Well, you can't just grab somebody walking down 42nd Street by the ears and rub their nose. You know, that's a crime. That's assault. You can't do that nonsense.
So the real trick is going to be able to, once you give them your simple notice, to be able to back it up by taking them to court, to common law court.
Yeah.
Be able to pull that off.
You don't even have to say common law court. That's what I'm saying. You just file your claim in court. And like I said, it's based on what you're writing. If you're saying the action is a trespass, and the trespass is, you know, administering property without a right, that's pretty well says it all. Trespass, you're not using any kind of California statute code for trespass under Section 1234, because I'm sure there's a trespass code in California. Okay. As long as your paperwork has absolutely no codes, it's not relying upon any precedents based on some code that happened in the past or any of their, you know, because you don't know how they moved Hale versus Hinkle. I don't know what jurisdiction they moved under. I believe it was under some sort of commercial law. And I know Hale versus Hinkle had something to do with an accountant of a fruit and vegetable company in New York, and the state attorney general from New York State was trying to acquire all the records from the company, and Hale said, no, you're just going to get the, what do you think we didn't pay taxes on? The import of what? Bananas. Then all the paperwork you're going to get is for the bananas. We're not going to give you the apples and oranges and watermelons and everything else. And New York State said, no, we chartered you, we created you. If we want all these damn records, you're going to give it to us. The United States Supreme Court said, no. The corporation has can use the Fourth Amendment, Fifth Amendment, the right to self-incrimination. They don't have to testify against themselves, and they could be secure in their paper and property just like a man who's sovereign. So everybody says, oh, Hale versus Hinkle. Supreme Court said man is sovereign. Well, basically have to do with an import-export company for fruits and vegetables. Now, if you want to say, rely your case on Hale versus Hinkle, okay. You know, you're just trying to stretch it and saying, well, a fruit and vegetable company has rights. Well, so do I. Why? Just say I'm a man. Just by saying I'm a man, there you go. They know you have rights. It's self-explanatory. Because only man has rights. Everybody else has a duty, an obligation, or chartered, or privileges, or something. But only man has rights. You just say I'm a man. There you go. When I enter course in commerce, my name is Bill. And there you go. And that's about it. You don't have to do uppercase, lowercase. You can make this, so when I enter course in commerce, I use the symbol formerly known as the artist known as Prince. Believe me, I'm sure when Prince went into a bank with that crazy question mark, whatever symbol he had, I'm sure his check cleared. I'm sure they said, oh, yeah, I recognize that symbol mark. Oh, yeah. That's what he uses to enter course in commerce in the public. There you go. Doesn't make anybody have control over him because he uses that symbol. Nobody could get into his personal affairs. Only person that he engaged with is the person that he put the paperwork to and said, I will willingly now consent to sign this piece of paper, and now I'm joined with you on you know, within this document, within the terms and conditions set forth in this contract. That doesn't mean the person can swing his body around. It doesn't mean he owns his body now. He sold his soul.